So in Module 1, we gave you an overall philosophy and framework for understanding the very basics about building and expanding successful relationships in your real estate practice today. And in Module 2, we tried to give you an idea and some concept of the scope and the breadth and the extent to which those relationships need to be built. We're hoping that you walked away from Module 2 with a lot of great practical ideas of what you needed to be doing today to expand your network of professionals to keep up with the increasing demands of the real estate profession. In Module 3, we're going to give you an introduction to Respa, the National Real Estate Settlement and Procedures Act, and we're going to talk about how that affects all of the relationships we concentrated on building in Modules 1 and 2. We're also going to talk about the nature of referrals and how that is impacted by the federal law. You know, one of the misconceptions and myths that's out there surrounding Respa is that the federal statute in some way limits or restricts our ability to make referrals to other settlement service providers. And nothing could be further from the truth. There is absolutely no language in the federal statute which in any way was meant to restrict your ability to make referrals to other settlement service providers who could benefit your client throughout a transaction. However, the concern often arises over what liability do we as real estate professionals have simply for the making of a referral. And the very basic answer to that is, well, not much. If, for example, I were to tell you to go for a sail and the boat were to look like this, well, do I have potential liability? I don't have liability simply because I referred you to the individual. For example, if I sent you to John as a mortgage lender and John did a really awful job and you got a poor loan and the matter wasn't handled properly, I am not automatically responsible for John's conduct simply because I made the referral. There is a way that we can be held liable, but it's only in the making of a negligent referral. So let's start out with the idea that there is no liability simply because we made a referral and that liability only exists for negligent referrals. So how do you make a negligent referral? A negligent referral would occur when you referred an individual to someone that you knew was not going to do a good job and would not perform to appropriate professional standards. That's when we have liability. And all of that liability for the potential negligent referral leads to one of the biggest myths throughout the real estate industry and profession. I call it the 3 business card myth. It's amazing how many real estate professionals and other settlement service providers believe that there is some law or requirement that I have to provide you with the names of several settlement service providers and let you as the client select from them. And that is simply not true. You have the ability as a professional to simply say, here is the one person that will do the best job, and I strongly would recommend that you use this individual. The reason that the business card myth got created in our industry happened in the 1980s. And in the 1980s, there were a handful of cases that dealt with negligent referrals. If I were to share with you the specific fact patterns of each of those cases, you would find some, well, amazing similarities. And I believe you would also conclude that those individuals probably should have been held liable. You know, nearly all of the negligent referral cases against real estate professionals are not for the referral to mortgage loan officers, title representatives, attorneys, or home inspectors. They almost always were cases where the real estate professional was making a referral to someone to make repairs to the home or the property. And yeah, you guessed it. That referral was almost always to a family member. The family member almost always was in some type of legal entanglements, whether they were being sued for past work they had done on their homes, or whether regulatory agencies like registrars of contractors had revoked their license or were pursuing them, and the agent still referred their client to that family member. Hey, I think we could all agree, in those kind of cases, we deserve to be held liable. But absent that, we should become very comfortable with making referrals throughout a real estate transaction. HUD, the past enforcer of Respa statutes and regulations, knew all too well that in a real estate transaction we often act as captain of the ship, and that our clients turn to us repeatedly to ask us for the names of the people who can help them most throughout the transaction. So in order to make certain that your boat passes those tests on referrals, just know that you're free to have whatever business practice in terms of the number of names you give to clients that you feel comfortable with. And some brokerages and some real estate entities have adopted their own rules and procedures. So check with your broker as to what the specific rules may be for your company. There's one more area that we have to carve out and discuss as separate from Respa before we get to the actual statute. And it has to do with the relationship between you and your clients. I have to tell you, I get phone calls and emails all of the time from professionals saying, I would like to give this to my client. Am I allowed to do that under Respa? Rule number one, Respa has absolutely nothing to do with the relationship between you and your client. Respa governs the relationship between you and other settlement service providers. We'll identify who those are and help you shape that definition a little bit later in the course. But for now, just know that there's nothing in Respa that governs what you can legally give a client for doing business with you. In other words, if during or at the beginning or the end of a transaction, I wanted to give this boat to my client, can I do that? Respa is silent on the issue. And what you can give to your clients is totally and completely a matter of state law. You have to look to your licensing regulations and see what licensed professionals can give to other people that are non-licensed for the referral of business. If it's your client, they're not a settlement service provider, so it's outside the scope of Respa. Let me give you an example of what our statutes say here in the state of Arizona, and you can compare them with the state in which you practice. In Arizona, only licensed professionals can receive anything of value for the referral of real estate clients. So that means no cash, no referral fees to non-licensees, and it applies to all non-licensees. That includes relocation companies, third-party short sale negotiators, and even attorneys. In Arizona, in order to receive a fee from a licensee for the referral of business, all of those individuals would need to have a real estate license. Check the laws in your particular state, because the issue on what you can give your clients is always a matter of state law. It's just not covered under Respa. Which brings us to the federal statute, the National Real Estate Settlement and Procedures Act, about relationships out there on the high seas of your adventures. First of all, Respa, it just ain't nothing new. Respa's been with us for some time. It was enacted in 1974, and all in all, it consists of 800 plus pages of federal regulations and statutes governing transactions in real estate. You'll be happy to know that in this course, we are not going to read to you all 800 pages, nor are we going to attempt to cover all of the numerous provisions. We're going to hit the highlights, and we're going to leave you with some practical tools that can help you drive your business forward in a way that's Respa compliant. When Respa was enacted, it actually had two separate purposes in mind. One was to increase disclosure, so the clients understood the nature of our relationships and also understood any benefit that we were receiving from them. It also wanted to make certain that the clients were aware of the disclosures that surrounded their particular mortgage loan or product, and also enacted to eliminate kickbacks, illegal fees exchanged between settlement service providers. Respa is a federal statute that is limited to 1 to 4 family residential property. And as a summary of the 800 plus pages of federal regulations, when the statute was passed, a preamble was written. And the basic content of that preamble says that the purpose of Respa is to eliminate kickbacks, which would add unnecessarily to the costs of certain settlement services. I mentioned to you at the beginning of this course that I, personally, have been studying and dealing with this federal statute for some time. I first had the opportunity to examine Respa as an attorney, and then as a real estate broker, and then as a mortgage lender, and today as an instructor who teaches this topic. I have to tell you, I think that the federal government got it right. Respa is enacted to help control the costs in real estate transactions and to keep real estate settlement service providers from buying clients in business simply by paying each other for those referrals and then increasing the overall cost of the clients. So keep that in mind as we work through the various provisions about Respa. I thought it would be interesting if, before we really focused on exactly what is prevented and what is allowed under the federal statute, to share with you some new messages about Respa and what has been going on in the last few years with enforcement. In the claims process for a plaintiff in Alabama, an Alabama brokerage was sued in a class action lawsuit by an individual named Busby for $13 million payout. It happened in October 2010. And it involved a claim against Realty South, who was sued for charging an administrative fee in addition to real estate commissions to a real estate client. The Busby case came to be known as the Administrative Services Fee Case. And you probably should know that the Realty South agent lowered their commission from 3% to 2.5%, and the client Busby was charged $149 administrative services fee. And by the way, the lawyer representing Busby in the class action was the closing attorney in the real estate transaction. So a little bit of background for you. The Realty South case really dealt with the issue of, could I charge fees over and above the standard real estate commissions that we so often have charged clients? And HUD's ruling was not a blanket outlawing or prohibition of such fees. What HUD said is, you cannot charge fees for services that are not performed. And the real problem with the Realty South administrative fee was Realty South couldn't document what the purpose of the fee was or what kind of services it covered. So we're not ready to say with the Busby decision that you couldn't charge certain administrative service fees. You just had to outline and document for the client what additional services over and above the real estate commission fee were those fees meant to cover. In June of 2010, HUD partnered with the FBI in a major mortgage fraud takedown, all related to Respa. And the Department of Insurance settled a kickback case against an Alaskan title company in 2010 based on violations of HUD. In 2011, HUD ruled that a payment by a home warranty company, an HWC, for marketing services performed by real estate brokers was an illegal kickback. Let me give you the general thrust and import of the home warranty decision by HUD. A home warranty company approaches a real estate professional and says, for every 5 clients you send us, we're going to pay you X amount of dollars, or we're going to give you 2 free home warranties, Or even better yet, we're going to give you $50 for every home warranty client you send to us. Does that sound to you like an illegal kickback? Well, it certainly sounded that way to HUD. In May of 2012, just within the last 24 months, the Freeman versus Quicken Loans case hit the United States Supreme Court. And it is a very interesting U.S. Supreme Court interpretation which affected the earlier HUD ruling in the case of Busby for administrative services. Because in Freeman versus Quicken Loans, a mortgage lender, was also charging some administrative fees, and Freeman brought suit based on HUD's previous ruling in the Busby case. In the U.S. Supreme Court, the U.S. Supreme Court said in Freeman, there cannot be a violation of Respa unless we are sharing or splitting fees with other settlement service providers. So that imposed some additional limitations on the previous HUD reach in instances like Busby, and it's our most recent decision out of the U.S. Supreme Court dealing with Respa. In July 2012, you should know that the United States Supreme Court refused to grant certiorari, which means they refused to hear a case of First American versus Edwards, which was going to have the court determine whether or not the claimant in Respa violations had to show actual damages. And by denying hearing of the case in front of the U.S. Supreme Court, the U.S. Supreme Court let stand a lower court ruling that a plaintiff bringing a Respa claim or violation against a real estate agent or their brokerage didn't have to actually even suffer actual damages. They just needed to show that the agent or the brokerage violated the federal law. You know, all of that enforcement has really occurred in the last couple of years. And within the last year and a half, the rise of an entire new entity to enforce Respa has come into being. They're called the Consumer Financial Protection Bureau. You'll see it abbreviated CFPB, and it's going to change everything that you have heard or learned up to this point about Respa enforcement, which always used to be under the purview of HUD. The new CFPB has opened 1,500 new cases just in the last 18 months, and they have spent the last year and a half doing things like hiring attorneys, finding investigators, building up their staff. So you can expect the next couple of coming years to be full of a lot of enforcement of Respa. Except it's not going to any longer come from HUD, it's going to come from the CFPB. One of the other things that happened with the recent amendments and changes to Respa was the swabbing up of the deck, I'm going to call it, from the mortgage fiasco. We now have a simplified new good faith estimate. In fact, you can find that new good faith estimate attached to the end of this module as a PDF file. And we now have, as many of you know, a brand new HUD 1 settlement statement. You know, the major differences in these forms between what we had seen in the past is that there are new tolerances implemented between the initial good faith estimate that's given to clients and what the eventual HUD 1 settlement statement looks like at closing. As hard as this may be to believe, you know, in the past, there never was really any legal enforcement or impact to an initial good faith estimate being far different from the final HUD 1 settlement statement the client got from closing. And I know we've probably all seen it, where a particular lender issued a good faith estimate and the client got to closing and the interest rate and costs were nothing close to what they had been quoted. The new HUD 1 and the new good faith estimate requires those numbers to be substantially similar. And based on the type of charge, there are some of the charges that can change a slight percentage, some which can't change at all, and it's added a new additional burden to title companies, escrow companies, and closing attorneys as they try and make certain that the final HUD-1 settlement statement is at least close to the initial good faith estimate issued to the client. We should all know as real estate professionals that HUD requires that initial good faith estimate to be sent within 3 days of loan application. From the date the client signs the loan application, they are supposed to receive a good faith estimate and this pamphlet, Shopping for Your Home Loan, which explains the costs in the transaction, within 3 days. Here's a practice tip for you. If you have clients out there that are shopping for loans and they've talked to a lender and applied to a lender and it's been several days or a couple of weeks without an answer, you should probably be reminding the clients of this federal law. It's an important disclosure requirement, and while we as real estate professionals and brokers don't have responsibility for providing the booklet or the form, I think at a minimum we owe it to our client to make sure they know what their legal requirements and disclosures are required. The new good faith estimate, as we mentioned, has these tolerances in it, and here you can see an example of the HUD-1 settlement statement, which now, for the first time on page 3, makes us lay side by side the initial numbers they were given on the good faith estimate next to what they're actually being charged at closing, so that the clients and the closing officials, whether they be in escrow or whether they be closing attorneys, can actually see those numbers and discuss them with the clients. So with all of those changes, you can certainly see that there's been a lot of activity surrounding Respa in the last couple of years. And my prediction, having been involved with this federal statute for the last 20 years, is that today, under the purview of the Consumer Protection Financial Bureau, the new CFPB, that you need to be increasingly aware of stepped-up enforcement efforts. If you want to get an idea of what this new Consumer Protection Financial Protection Bureau is all about, then I would simply tell you to go to Facebook or log on to Twitter, because they have established a regulatory agency in a whole new world. And they're using Facebook and Twitter to promote the kinds of information that our clients need to be aware of and walking them through the process of how to file a complaint or get their concerns addressed. So be aware. It'll help keep your boat off the rocks.